growing up in a family where my father was a healthcare administrator, my mom has a very rare genetic disease, so I understood sort of the constraints she participated in numerous clinical trials at NIH, that there was like a real, that I can make a difference being a lawyer and practicing in healthcare. So while I was at Cardozo, I also got the certificate in bioethics and medical humanities through Montefiore, and found my way. I actually interned with David Hoffman at Wyckoff Medical Center when he was there, and then did a separate independent study at the time with Nancy Dubler, who ran the bioethics program at Montefiore Medical Center, and found my way to Garfunkel Wild, which is a mid-sized healthcare firm in Long Island. There I sort of worked the whole spectrum of healthcare, and probably the closest area that I touched really in bioethics was doing like clinical trial work on behalf of hospitals, negotiating against pharmaceutical providers, but really on the financial side of what they were going to get paid for participating in the trial, making sure that the hospital was protected if they needed to deviate from a protocol due to a safety risk to the patient. And I did get the opportunity at the time to serve on Hospital for Special Surgery's IRB, so I got to practice a little bit in that way as the community. I was serving as the community member. And that was the time actually that the Family Healthcare Decision Act finally got adopted to hospitals. So I got to do a little bit of work towards the end in creating policies and procedures and setting up the ethics committee mandated by the Family Healthcare Decision Act at a bunch of hospital clients. From there, I got the opportunity to go in-house to be the Associate General Counsel at Visiting Nurse Service of New York, which is where I really got to merge my ethical training and my law degree. BNSNY has the largest home care, not-for-profit home care system, I actually think in the country. I don't know if that's still accurate. They also have a very large 900-patient hospice program, mental health services, and some other programs. While I was there, luckily the Family Healthcare Decision Act actually got expanded to include hospice. So I got to help sort of build out the Hospice Family Healthcare Decision Act program. And interestingly, there's a huge gap in the Family Healthcare Decision Act because it doesn't apply to home health or persons who are not in the hospital or not in the hospice program, which was a large percentage of our population. And so I was actually constantly, as the Associate General Counsel, sort of weighing the benefits of like technically violating the law, but doing what was ethically right for these patients who didn't actually have a healthcare proxy, or maybe they couldn't find the healthcare proxy, but they had had a family member who had been very involved in their care until the patient lost capacity, and sort of bending the rules there to say that it was more likely than not okay that this person continued to make decisions on behalf of the patient. And I also served as the privacy officer, with, interestingly enough, there's a lot of intersect between HIPAA and bioethics, and gaps there also in terms of the law doesn't always cover all of the scenarios. So I was there for 4 years, moved into the compliance department, but continued to co-chair the Hospice Ethics Committee, which took on not only doing case consults, but also organizational ethics and looking at truth-telling and moral distress of the clinicians providing hospice care, and also was continued to serve on the IRB at BNSNY because we did a lot of sort of data analysis that needed the IRB related to elderly and disenfranchised patients. And last April, I decided to go back to big law because while I found working in-house really, really interesting, frankly, it was exhausting to deal all the time. There was a lot of really heavy patient issues that we were dealing with. I also found that some of my legal training was not, I wasn't really growing as a lawyer as much because there's so many fires to put out in-house. I sort of had to outsource a lot of the interesting work that I wanted to do. I was no longer able to sort of write articles in other areas of the law, and wasn't able to work with a greater variety of clients. So I left and went to Manat. And there I'm still sort of trying, frankly, to find a balance of how I can still work or do some work in bioethics while serving because it's a big law firm and our rates are high, we don't get always to work with some of the community-based providers that I historically have worked with, although some. We do have a few small clients and a bunch of FQHCs actually that I help advise. And because I still do a ton of privacy work, I actually get to work a little bit in bioethics as it relates to issues that come up around disclosing information.
Randy, an FQHC is?
Oh, I'm sorry, a federally qualified health center, which is a special designation for centers that serve in metropolitan underserved areas or some underserved populations.
Professional shortage areas.
Yes, professional shortage areas. So they serve the underserved and they get grant money to do that, and they have to provide primary care services and certain specialty services and get special benefits. And the client that I do a ton of work with actually predominantly serves the homeless population as well as the severely mentally ill. So in that way, I'm still sort of contributing back. But I've only been there, I've been there less than a year, so I'm still hopeful that I'll find a way to sort of continue to bridge my legal experience and my ethical experience into bioethics to help some of our bigger clients. I hope I didn't take too much time.
Thank you. No, you were dead on. 7 minutes. Great job. Thank you, Ray. Adira, how did you wind up going from practicing law to seeing patients at the bedside?
So my story is that when I was in law school, so I never wanted to be a lawyer. I don't know how many people who are lawyers start that way. I've heard people talk about it like, I wanted to be a lawyer since I was 4 and I can't understand it. Like, to me that's sort of incongruous, but because I'm not sure that anybody can sort of define what a lawyer does, because we fill so many different capacities. But I was interested in social work and I was interested a little bit in law, and I had a conversation with my father who had never told me anything ever to do with my life. It was like, it's your life, you make your decisions. And then he said, you'll make no money as a social worker. So now I make no money as a lawyer. I made no money as a lawyer either. I should put that out there. So I decided to go to law school, and then I did family law clinic because I knew I wanted to work with children. That was sort of my inclination. And I interned for legal aid in law school, and then got a job at legal aid juvenile rights practice directly out of law school. I did trial law there for 12 years. And then appellate law there for 2 years, then back to the trial office for a couple of months before I moved careers. So I have actually only been a practicing bioethicist for about 7 months, but I have been thinking about bioethics since at least 2007. And that is because, and I think a little bit before, I just didn't know the name. You know, when we were practicing with juvenile delinquency law, we talked a lot about, can we use MRI results in order to prove show brain development, and say that a client of ours might not have been aware of consequences or able to sort of formulate his decision making in a way that should, to affect sort of, we use MRI results to like talk about should it affect sentencing or not, which there are some seminal cases in that now. So that was sort of bioethics-y, even though I didn't know it. But in 2007, I had a personal experience that led me to read an informed consent, a 22-page informed consent. And as I read it, and I kind of thought, I'm a lawyer, I've done a lot of critical reading in my life, and I have close to no idea what this says, right? I'm not sure. I kind of get it, but I kind of don't get it. I kind of get the risks, I don't really get the risks. Are there benefits? I'm not sure. And I decided, like, how does this get done? Like, how is this made? And I started asking questions about that, and I wound up joining the IRB at Mount Sinai, and as a community member. And I did IRB work for 4 years, but during that time, I thought, okay, I'm really into this research ethics thing, I'm really interested in it, and I started going to more bioethics things, and I learned about this field called clinical ethics that I didn't know existed, where people answer or attempt to answer, or attempt to do process work for ethical issues that arise at the bedside. And to me, I think it was evocative of so many of the things I loved about juvenile rights practice and representing children in abuse and neglect proceedings, which is people who are in a critical moment of their life, where there are so many things to process, they're so fragile, they're being asked to make such large decisions, and in a very effectively hot state, and working with people in that situation. And I was so interested in what does that look like in the hospital. I know what it looks like in a courtroom, I know what it looks like a little bit outside the courtroom, and so I decided to go back to school to get a master's in bioethics. I came here to Columbia, and I crafted my coursework around clinical ethics work, taking courses in the nursing school on end-of-life care and palliative care, in the narrative medicine program on death and dying and health and social justice, and then of course all the core classes in the bioethics program. And really and conflict, I took a class in the School of Conflict Resolution for advanced negotiation mediation. And all of those things I felt like were kind of crafting this hopefully package where I could present to someone and say, hey, I'm not a doctor, I'm not a social worker, I'm a lawyer, but I want to do this ethics work. And I actually had been told by a very prominent bioethicist, not connected to here, lawyers never get jobs in clinical ethics, you shouldn't even try. And that was a little bit off-putting to me, but I kept saying it can't be true because Nancy Dubler, who started the ethics program at Montefiore, is an attorney, so there's got to be some space for me in this. And I took off 4 weeks from work to do a rotation at Columbia Presbyterian with Dr. Ken Prager, who is the clinical ethicist there. And he has very long legs, he's very tall, and I spent like a month chasing after him and realized that it really spoke to me and it was what I wanted to do. And any opportunity that came up to meet with people and discuss and to network and to meet with other clinical ethicists I took. And I got to meet Dr. Hannah Lippman, who is my supervisor and is the chief of the clinical ethics or bioethics consultation service at Montefiore, who I now work for and with. And I kept in touch with her, and when a job opened, I applied for it. I learned about it from her, and I applied for it and went for it, and I feel incredibly blessed to have been chosen to do this work. How much time do I have?
You have plenty of time.
I have plenty of time. Am I talking crazy fast? But I heard a couple of things come up when people were talking about their career, specifically working with the elderly. And then when Randy was talking, I thought I'd mention a place where law and bioethics intersect all the time in the hospital. We work very closely with legal counsel, but the fastest growing population in our clinical ethics service is what we call patients alone. Some people call the unbefriended patient, who is a patient without capacity, who lacks capacity and is isolated from friends and family, meaning they have nobody to make decisions for them. And they are a growing population, and we get called all the time from doctors who are so thoughtful about these patients. How do we figure out goals of care for this patient who can't guide us? We have no advanced care documents, so no living will, no advanced directive to tell us what this person, he or she, might want, and how do we move forward? And these are often life and death decisions that are being made. I mean, it's death or death, and sometimes, in a few months, but it's meaningful because these people have lives that where sometimes we determine the meaning of somebody's life by what people tell us about that person, right? And we don't sort of think, what is the independent meaning? What is the independent dignity of this person? And by doctors consulting us about these patients alone, we have a time to really be thoughtful and to deliberate about what is best for this person and what might they have wanted, and to do a lot of work in trying to unearth anybody or anything that could give us some idea of what their values are. And in August, there was an amendment to the Family Healthcare Decision Act that allows these patients alone to be enrolled in hospice. Before, they weren't allowed to be enrolled in hospice because of kind of a strange pocket of the law. And now they are allowed, and it requires an ethics review committee it requires an attending physician, a separate, independent decision by another attending, and a review by the ethics review committee, which we would assemble as a bioethics service. And so there, that sort of thoughtfulness about that population has sort of a mix of legal, a mix of medicine, and a mix of bioethics all together. And I have found, working together with legal counsel in the hospital and with the doctors, that it's not a bad mix, actually, to sort of process the law along with medicine and bioethics. think if there's anything else that I wanted to add, I jotted something down. Yeah, I think that's good. Does that
All
work?
right. Well, we'll have questions at the
Yeah.
end, so save your questions. And now we're going to move on to David Levin. And David has been at this work on lots of different levels for a bunch of years, also having found his way to bioethics, I won't say by accident, but not according to a strict plan.
Purely by accident.
Tell us what the accident was.
I was looking for a new job. And it came along. So I wasn't going to become a doctor because when you flunk high school biology, it's probably not something you should seriously consider. My father was a doctor, and I think he would have been happy if I had become one as well. So I became a lawyer, and actually, just to show you how old I am, I went to law school with Joe Biden. He was a classmate of mine. And so I started to engage in public interest law. That's been my career pretty much. And this is public interest work that we all are doing when we're working in the bioethics field. I was in legal services for the poor lawyer for 10 years in Rochester, and then for 20 years I was the head of a statewide prisoners legal services program. And now for the last 14 years I've been working for End of Life Choices New York, formerly known as Compassionate Choices of New York, working on end of life issues and trying to actually working towards trying to change the culture of death and dying to the extent that we possibly can, and to improve care at the end of people's lives, and to try to ensure that people have their health care wishes respected and get the kind of care and treatment which they're entitled to and to which they want, but not get unwanted care. And there are so many problems which still persists in this area as people are dying, and it's quite amazing. And I think my colleagues here will agree that most doctors have never been well trained when it comes to end-of-life care, palliative care, hospice care, pain management. Only 4% of medical schools in this country actually have a mandatory course in pain management, only 17% even an elective course. And so you have lots of people who are seriously ill and dying who are being treated by doctors who don't necessarily know how to treat, and then they don't refer their patients to palliative care even when patients could benefit from palliative care. And there are actually laws now in New York which probably doctors don't even know about to a large extent, so they're being widely disregarded. Let me mention one of the laws called the Palliative Care Access Act, where now in hospitals and nursing homes and home health agencies, institutions are required to provide palliative care to patients with advanced life-limiting illnesses who might benefit from palliative care. Does everybody know what palliative care is?
Just about to say, David, why don't you define palliative care?
I'll do the best I can.
Absolutely.
So palliative care is the provision of care to a patient who is sick, usually in a hospital setting or nursing home, does not have to be terminally ill, and the care that's provided is often by an interdisciplinary team, although it doesn't have to be, consisting of a doctor or a nurse practitioner, a social worker, chaplain, all kinds of therapists that can help this patient and family members to achieve the best quality of life, both for the patient and family members. Is that pretty close?
Yeah, good.
Okay.
And it's non-curative care. So it's
Yeah.
everything that we can do for patients if we think that we ought to, and clinicians need to think of that more often, but it's everything in addition to or in place of curative care if there are no curative care options.
Right. Although curative care can be provided
Absolutely.
simultaneously, as
Right.
long as the person has not been determined to be terminally ill, and even there now that we're beginning to recognize that, you know, even in hospice, many people won't go into a hospice because they say I can no longer get treatment for to cure my disease, and that's beginning to change. There's now an experiment going on across the country in some 150 hospices which are allowing people to get disease-modifying therapies at the same time that they're getting hospice care, and I think that's going to be the trend, as I think also hospice will probably be expanded, as it should be, to 1 year from 6 months.
Quick definition of hospice?
Okay, hospice is a sort of a subset of palliative care where, again, by an interdisciplinary team, care is provided to a person who has been determined to be terminally ill and with a reasonable degree of medical certainty will die within a 6-month period. So there are a lot of issues that arise just around that itself, and what happens when people are determined to be terminally ill. For example, does a doctor have an ethical obligation at that point to inform the patient of the fact that he or she has made a determination that you are likely to die within 6 months, and to provide information about palliative care and end-of-life options which might be available, and the risks and benefits of those options? What do you think? Ethical obligation to do that? Absolute obligation? Yes? No?
Yes.
Okay, how about the situation where the doctor says, you know what, my patient is a little bit depressed right now, they're not doing so well, I don't think they're ready to hear it. What, doctor, you have an ethical obligation still? Speak up.
It's maybe not so much the what, but the how. If you handle it the right way, because if you have to deliver, let's say you could bring in a social worker, you can consult with social worker,
Okay.
You can consult with colleagues in the how to discuss this, and timing is everything. Patients having a bad day, maybe not that day, maybe the next day.
But you still think it's an absolute obligation up to this point. Now the spouse of this person says, my wife is really not ready to hear this, and please, under no circumstances, do not inform my wife that she is terminally ill. What do we do there?
How many people would honor the instruction of the wife of a terminally ill patient to withhold that information from the patient? Show of hands.
Could I actually tweak it a little bit and
Sure.
ask if there's a cultural requirement in terms, if you go globally, let's say this is a family that's coming here to be treated, and culturally that's required.
So allow me the latitude to reject your tweak, excuse me.
For now.
I have tweet
Wow.
on the brain as someone whose name will remain unspoken.
He and Donald Trump are tweeting back and forth.
So let's hold that modification. Let's stay at the core question of whether it is ever ethically appropriate to follow the instruction of a loved one, a wife in this case, to withhold a diagnosis from a patient. Who feels like that's okay? Not so many of you.
And I mentioned this is a very frequent
Yes,
Oh.
I was about to say that.
bioethics
Just
consult.
about
We
everyone.
get this call.
All right.
Withhold for how, indefinitely, or?
So in this hypothetical, the wife is saying indefinitely, or at least until she decides some circumstances change to warrant it. So this is the crux of bioethics. And we can talk more about this after we've wrapped up our presentations, because I've left lots of time for discussion, because that's what bioethics is about. It's storytelling and discussion, respectful, orderly, reasoned discussion.
So the last thing I'm going to mention briefly is that my organization is one which works to expand choices at the end of life. And so we are supporting the right of terminally ill, mentally competent adult patients to access Aiden Dying, as we appropriately characterize it, as opposed to physician-assisted suicide, which is the process by which that patient may obtain a prescription of medications which the patient can take or not take if they choose not to, and many actually don't. In Oregon, about a third, to end their suffering and to achieve a peaceful death. And so there are ethical questions there about whether or not it is appropriate to allow people who are in that situation to end their lives in this manner, as opposed to some other manner, which, and of course we know it's now appropriate for people to have life-sustaining treatment withheld or withdrawn after it started. People can now voluntarily stop eating and drinking, which is an increasing way for people who are suffering at the end of their lives to hasten their deaths essentially and end their suffering. And now also since 2008, the AMA has recognized, and other organizations, that people have an ethical right to have palliative sedation if their suffering can't be controlled by any other legitimate medical means. So they're sedated to unconsciousness, and the life-sustaining treatment's generally withdrawn at that point, and then they die of dehydration within, it can be hours, or it can be a couple of weeks. So then the question is, what about Aiden Dying? Does that fall into the same category as these other things? And If not, why not? If so, why so? We're strong proponents and believe that it is clear that Aiden Dying is something which is ethical for this group of people who are terminally ill, mentally competent adults who are suffering to such a great extent that, and they may not be on life-sustaining treatment. So this is a better option for them, a better option than voluntarily stopping eating and drinking or palliative sedation if they're suffering from some kinds of serious physical symptoms. So I'll stop there and...
No, don't.
Don't, okay, I won't stop here.
David, talk about the debate that is intrinsic in the legal challenge that your organization is advancing to establish a right to aid and dying.
Okay, so my organization initiated a lawsuit that's pending in state court now. It was brought in the state Supreme Court. We lost. The case was dismissed on papers only, which much to our dismay. A terrible decision from my perspective. We had argument in the appellate division of state Supreme Court in Manhattan, February 3rd. We think the argument went really, really well before 4 judges and think that the court is going to reverse. And so what we are seeking is a ruling ultimately that under the New York State Constitution's provisions, which of equal protection and due process, that patients have a right to obtain and physicians have a right to prescribe without being subject to discipline or criminal prosecution medications which the patient can take. And the case was brought by, interestingly enough, the same 3 doctors who brought the case of Quill against Vacco, which some of you might be familiar with, that went to the U.S. Supreme Court, where the Supreme Court held in 1997 that at that time there was no such constitutional right under the federal constitutional provisions of due process, equal protection actually in that case, due process in a case that was heard and decided the same day from the state of Washington. So this case is only based on state constitutional provisions. It'll only be in the state courts. And we're also asking the court for a ruling that under existing statutes in New York which ban assisting a suicide, that what we characterize as aid and dying is not something which falls under that statute. So doctors can't be prosecuted. So it'll be an interesting ruling, and we're hoping actually for a ruling on both if possible. Of course, what courts do is they will avoid the constitutional issues if they feel that they can just rule on the merits concerning the statute itself. And do you want me to tell you why we think it's not assisted suicide? Is that what?
Yes.
Because I don't want to.
We're good on time.
Okay. So if you think about a person who commits suicide and with assistance, or not, a person who commits suicide is almost always a person who could continue to live but chooses to die. It's a person who does commit suicide almost always in isolation without any discussion with other people, friends, relatives. It's a situation where oftentimes the suicide is committed violently, not always. The person often does have, not always very serious or somewhat serious, psychological or emotional, psychiatric problems which could be addressed. And it's really tragic. Aiden Dying is so very different. Aiden Dying is the process by which, again, a mentally competent terminally ill person is going to end their lives with prescribed medicines. And the way the process works is it's a very open process which, generally speaking, takes 7 weeks on average from the time that the person requests the medication from their doctor until the time that they take it, if ever. And again, almost 1/3 of patients who get the medications, in fact, never take them. It's always done in consultation with physicians because at least one physician has to prescribe. And under the laws in most states now that have legalized Aiden Dying, a second physician, consulting physician, has to make a determination the person is terminally ill, mentally competent, not suffering from depression, does not need to be referred to someone else for consultation before the medications can be prescribed, and almost always with family support, and 90% of the patients are actually receiving hospice care, at least in Oregon. So the process, so it's a completely different process, and in the end, this is a process which is really about empowerment and about autonomy for the individual patient who is dying. This is not a question about whether the patient can live or not. The patient is dying. It's only a question as to how the patient is going to die. And so it is so much different than suicide, and we think the two should be distinguished. Of course, our opponents on the other side are trying to conflate the issue, understandably. The New York State Catholic Conference, for example, has filed an amicus brief, even though in the appellate division, and amicus briefs aren't filed that often there.
Friend of the court briefs.
Friend of the court briefs. Not dead yet. A disability rights organization from upstate filed an amicus brief as well. And of course, the Attorney General feels that they have to defend, and they submitted a pretty good brief in the appellate division. So we'll see what's going to happen in New York, and I do think that ultimately, if I were to be a betting person, and I am, that the New York State Court of Appeals, our highest state court, will probably rule that for one reason or another, that Aiden Dying is a right which people should have.
And what David is doing is really the ultimate synthesis of the practice of law and the advancement of the values of clinical bioethics. It is at the heart of what we do when we're advocating for patients or advising clinicians, as I do, where we're trying to define the environment within which care is provided so that we are doing everything we can for the patient in terms of curative treatment, and in conjunction with that, and then when that curative treatment has run its course and is no longer available, that we're still doing everything we can in terms of palliative care, which is the generalized relief of pain and suffering and providing support, which then in turn sort of rolls in many cases, to hospice care, which is all of the goals of palliative care in the setting of an immediate end-of-life diagnosis. So that's where it all comes together. Question?
So if the court rules in your favor, and you
Yes.
get a guideline or a model from another state that has worked well, but you
And one thing I did not mention, we also have legislation pending in New York. There are two different bills that have been initiated to establish Aiden Dying in New York. They're probably going to be unified over the coming weeks. I'm working on that, spending too much time on it with different legislators. The bills aren't going to necessarily go far in the near term, but assuming that there is ultimately a court decision which establishes the right to Aiden Dying in New York, the legislature will definitely want to enact legislation with safeguards, restrictions, and so forth, which the legislature feels is necessary, but which hopefully won't be unduly burdensome on people who want to get the medications and take them. And I'll give you just an example of what can be unduly burdensome. In Oregon, for example, under their Death with Dignity Act, there is a requirement that there be a 2-week waiting period from the time that the first oral and written requests are made. There has to be at least 2 oral requests and 1 written request to get the medication. 2 weeks is a long time for some people, even though, as I said earlier, the process more often than not takes an average of 7 weeks or so. But you don't have that same kind of requirement. If you want to have life-sustaining treatment withdrawn, you don't have to wait 2 weeks. Now, the process might, in fact, take that long if an ethics committee is going to be involved and so forth. But there's no statutory requirements. There are all these statutory safeguards and requirements and restrictions in the Oregon and Washington laws, the Vermont law, which was also passed by its state legislature in 2012. Then in Montana, it's only standard of care. The Montana State Supreme Court ruled that under its existing laws, healthcare laws, that there is no prohibition on doctors prescribing or on patients being able to access life-ending medicines if the patient is terminally ill. So it's just totally standard of care, which I think ultimately 30 years from now, this will also be throughout the country. In fact, I also think that eventually the U.S. Supreme Court is going to reverse itself. Because even though in 1997 the decision that it rendered may have been a correct decision, at that time it had absolutely no evidence of how Aiden Dying was going to work in the various states. Now it has 18 years of evidence in Oregon, and it's been shown that the law has worked extraordinarily well. There's now 8 years of experience in the state of Washington. The law has worked extremely well there. No real problems whatsoever, no vulnerable populations. none of the problems that were expected to emerge by opponents of Aiden Dying have in fact materialized, even though the same arguments, which are now really stale and have no validity, keep on being raised by those who are opponents. Long answer to your question, sorry.
So I saved myself for last because I am the complete counter example of a career in bioethics. I decided that I wanted to be a lawyer when I was 7. And I decided I wanted to be a medical malpractice defense lawyer, defending doctors and hospitals in malpractice litigation, when I was a freshman in college. I got into healthcare having taught CPR, and then I started the ambulance service at the University of Buffalo and learned a lot about healthcare delivery literally at the ground floor on the street, which I draw on literally every day. And I was happy as can be going to court, trying cases. The only two parts of being on trial I didn't like were scheduling witnesses, because they're mostly doctors and that's just miserably difficult, and settlement negotiation. Because you know what, when you get a case ready for trial and you get into court, you want to try your case. There's a moment that every trial lawyer has experienced that we teach ourselves to be on guard against, and that's the moment when you start believing your defense and sort of lose your perspective. You have to be careful about that. But I was going about my business when one day a new file landed on my desk, and I opened it up, and it was an interventional neuroradiology case. I knew nothing about interventional neuroradiology, but the great thing about being a malpractice defense lawyer is it's like going to medical school for your whole life, and there's no exams. So every case was something new to learn about, and if you love medicine and if you love argument and discourse, it's a wonderful combination. So I had this case on my desk. It involved, of all things, an interventional radiologist. That's a radiologist who doesn't just take pictures, but actually does things. It's sort of a marriage of imaging, radiology is imaging, and actual treatment. So it's sort of a little like interventional cardiology in that it involves lots of threading of tubes into people's bodies, and so when it's interventional radiology, you're often doing it while looking at an image under a fluoroscope, which is an X-ray movie camera. And this particular doctor, who will remain nameless, even though he's no longer with us, he was injecting silicone glue into people's brains, which seemed odd to me at first. But I continued reading the file and learned that this was, for many patients, the only available treatment for two kinds of brain blood vessel abnormalities. One is called an aneurysm. That's the proverbial bubble in the side of the tire on a bicycle when the tube pushes out through the sidewall of the tire. Very dangerous if it bursts, obviously. And the other is called an AVM, an arteriovenous malformation, which is a jumble of blood vessels that don't form properly and therefore are kind of weak and delicate. And so what Dr. S would do is he would thread a catheter, and I just was fascinated by this. Thread the catheter up through the groin, up through the arteries into the brain, and steer the catheter by turning the bend in the tip to get it just where the problem was. And then he would get some 2-part silicone glue, and in 2 separate channels of the catheter, cannula, he would insert the glue and the hardener, and the theory was if they came out at the tip at just the right spot, at just the right moment, they would harden and form a seal. And it worked really well a lot of the time. sometimes not, but these were patients by definition who were at the end of the line. There was no surgical option because the defect was buried so deep in their brain that if you tried to do an operation, you might succeed in sealing off the defect, but the patient would die. So this particular case that landed in my lap was the family of one of the people who didn't have a good outcome, as we euphemistically like to say. And they couldn't criticize the treatment because there was almost no one doing this kind of treatment. So who are you going to get to say that Dr. S did it wrong? So they said that he was engaging in human subject research without proper research consent. So I had to learn everything there was to know about human subject research protection. And so I did, and I got paid for it. Life is good. We went to something called a medical malpractice mediation panel, and I presented my arguments, and we won, and that became evidence at the trial, and we went to trial, and wound up settling the case for what we would call trial costs, because the plaintiff's lawyer realized that they didn't have an argument, right? When you're treating someone and your intention, this is where the philosophy comes in, where your intention is to do what you can for this patient, as opposed to trying something out on a patient for the purpose of developing a body of knowledge to be applied to other patients. The latter is research. The former is treatment. Not all treatments are as well developed as others. This was my argument. But it was still treatment. And so that was how I got my first toe in the water of research ethics. And from that I became the go-to guy in my office for everything. So end-of-life treatment, refusal of treatment, the right of clinicians to refuse to participate in treatment, the conscientious objection to birth control, termination of pregnancy, the euphemism for abortion. And one thing led to another, and the head of one of the hospitals I was representing at the time said, you know what, we need an in-house lawyer. It would be great if we had someone who could do all of the commercial stuff and the contracts and the regulatory and also handle clinical matters. So that became my job. That's just, it's about as good as it gets for somebody like me. And I did that for 9 years, and then I assumed my current position, where I am the corporate compliance officer for the group medical practice called PAGNI, which is the medical staff practice for 6 out of the 11 health and hospitals, the public hospital system facilities, running from the very North Bronx to the very south of Brooklyn. And what I do is I advise doctors on what their responsibilities are to their patients. I don't so much get directly involved in patient consultation at the moment, but I'm the resource for the clinicians who are trying to decide what is the scope of my responsibility and at what point am I obligated to say either I can't do what is needed or I shouldn't do what the patient is asking for or what the patient's family is asking for. So that's what I do now that enables me to combine my healthcare regulatory experience with my clinical bioethics experience. And because that's not enough, and because I don't have much interest in much else, I also teach bioethics on the side. So I teach in the master's program here, obviously, as well as in the master's program at Cardozo Law School and Albert Einstein College of Medicine. And then during the summer, I teach a course up at the Medical Center at Columbia in the clinical ethics of clinical psychology. So there are lots of opportunities to either take a brand new law degree and find your way into clinical ethics on the compliance side, at the bedside, somewhere in between in a public policy setting, and also, as you've seen from the four of us, to morph your career in a direction that you never thought you were going to, based on the skills that you develop in some other area of the practice of law. And as I said in the introduction, the advent of reimbursement for the kinds of work that needs to be done so that patients are able to have their wishes followed at the end of life, that with an aging population will become more and more the work of clinical ethics, and our expectation is that the approval of reimbursement, what are called CPT codes, the current terminology and practice codes that are the lifeblood of healthcare reimbursement, that with the introduction of these two CPT codes for end-of-life care planning, more opportunities to contribute to the economic health of our healthcare delivery system by being better stewards of those resources, by helping patients make better decisions about what care they want and what care they don't want. That will be the future, the bright future of clinical bioethics. A cautionary tale. As David pointed out, this isn't easy work and it doesn't come quickly. Randy and Adira both mentioned the Family Healthcare Decisions Act. We spent 17 years advocating for the passage of what was really, in the scheme of things, a simple and obvious need. At the time that the Family Healthcare Decisions Act was introduced by New York State Assembly member and chair of the Assembly Health Committee, Dick Gottfried, a graduate of Columbia University, who actually joined the Assembly while he was still in law school. It took 17 years because these kinds of issues tend to attract controversy, even if it's not embodied in what is trying to be done. So for example, 17 years ago, there were only 2 states in the nation that didn't allow family members in their capacity as family members to participate in decision making for their loved ones when they couldn't make decisions for themselves. And those 2 states were Missouri, which gave us the Cruzan decision, and New York. And New York was only surprising because New York is sort of ahead of the curve in so many areas in bioethics. We have a state-funded task force on life and the law, which is a bioethics panel. And we have all of these educational programs in bioethics. So I did my training here at Columbia in bioethics 22 years ago. So Columbia's been at this for a long time, and we've actually gotten pretty good at it. The Montefiore Bioethics Consultation Service is, if not the oldest in the country, one of the top 3, started by Nancy Dubler, who was one of the co-founders of the program that I did in 1994. And yet, as David has learned with the Aiden Dying legislation, these kinds of public policy and ethical legislative initiatives tend to attract controversy. So the Catholic Conference, for example, which is not, by the way, representative of the Catholic Church at all, and in fact has taken some positions that are antithetical to the teaching of the Catholic healthcare system, they created some really difficult and improbable obstacles for the passage of the Family Healthcare Decisions Act, one of which was an insistence on a provision for what would be done with pregnant, brain-dead patients. That happens about twice a year in the entire country. And what's done clinically and ethically is pretty obvious. If a patient winds up in the hospital and is pregnant, one would infer legally and ethically that the patient wanted the pregnancy. They were still pregnant. And so we would do everything clinically to see to it that that baby was born if that was medically possible. And yet that issue became one of the stumbling blocks for the passage of the Family Healthcare Decisions Act. An example of the law and bioethics operating in opposition to each other. But that's part of the profession also. So there you go, 4 very different experiences with bioethics and legal practice, from both a career perspective and from a clinical perspective and a public policy perspective, and from Randy from a business perspective. But an enormously interesting and rewarding area for someone who has an inclination toward law, but also has some sense that healthcare is different than other areas of law, a bright future. I think if you're thinking about either entering this area as your career in the first instance or as a change in career, there couldn't be a better time. And programs such as the one here at Columbia are a wonderful vehicle for getting yourself up to speed, either moving out of another legal professional practice area or starting out from scratch. So plenty of time for questions, right? We have 15 minutes. Questions, fire away.
Is not having a law degree or having it can be a hindrance for this?
You know, some would say it's an advantage. Funny, another story I was going to tell. When I was doing my bioethics training here, yeah, and if you have to run, feel free, don't feel embarrassed about having to slip out. When I was doing my training here, the head of clinical bioethics at Columbia was Tia Powell, who is now the head of clinical bioethics at Montefiore. It's an incestuously small community in a really wonderful way. I had just met her, I think it was maybe our 3rd class, and she said to me, "David, are lawyers positive or a negative influence on bioethics?" I thought it was really a loaded question, and maybe impolite, since we didn't even know each other. Now a question like that would, just roll off my back. But I said, lawyers are incredibly powerful actors in our society generally, and so they are either a very positive influence or a remarkably negative and obstructive influence. And that sort of manifests in the statements I get from my medical students often. When I ask them, well, what does it mean to be an ethical clinician? And every year, 2 or 3 of them will insist, well, you have to do what the law requires. And that is a definition of being ethical. And that is what, as a philosopher, I would say is a sometimes necessary but never sufficient condition.
I would say also, from working in hospice and home care, that we tried so hard to sort of meet clinicians, stewards of bioethics, down to the line staff, because there is so much that needs to be done to be legally compliant, like your documentation and getting through your caseload and all of that, that every time we would try to send somebody out to be a steward or do a presentation from the co-chairs, which were a lawyer and a professional bioethicist, there was never time, and it really needed to be more organic, to be really effective, and to create a top-down, bottom-up culture of ethics, not just in bioethics, but as an organization. So also, I think that lawyers sometimes within an organization are sort of seen as the police or the people you go to as, the last place you want to end up, because you really don't want to be making an ethical decision based on what the legal parameters are if you can help it, because sometimes it doesn't always allow you to make ethical decisions. So I actually think being a clinician is a wonderful place to start doing bioethics, because you're actually able to organically sort of change how the practice is happening at the line level, because 95%, at least at BNSNY, and even when I consult externally, of the ethical decisions are not coming up to the ethics committee. Maybe they are at Montefiore, but they weren't at BNSNY, And they're not coming up to the legal department, they're being made by managers and line level staff or team meetings. So I really encourage that like anyone working in healthcare has exposure to bioethics, because that's really how you're gonna make it impact the patients most effectively.
Let me add a footnote to what Randy said, because I can get away with saying this and perhaps she shouldn't. There's a lot of wiggle room in bioethics, and lawyers, other than those who are deeply immersed in the ethic of bioethics, are less inclined to take advantage of that wiggle room. And that doesn't mean that those lawyers are being bad lawyers. It just means they're not thinking with a fidelity to the bioethical prerogatives of clinicians. And when you're advising doctors and institutions, your advice ought not to be what is the safest, most risk-averse approach, because it is not the function and the responsibility of a clinician, and we use the term clinician to describe the entire range of healthcare providers so that we don't fixate the conversation on doctors or physicians. So when you're a lawyer advising clinicians, you ought to be advising them to use their discretion for the benefit of their patients. And sometimes that will mean pushing boundaries in the way that David described pushing boundaries. And sometimes that involves deferring to a family member because you believe what they're saying is true and sincere, even though you could legally drag that family through a litigation process and have the process make the decision rather than the clinicians.
Well, first of all, I was going to say that at the roots of bioethics is a interdisciplinary and multidisciplinary cast of characters. I mean, that's how bioethics came to be. So it's certainly not, I wouldn't say, like the lawyers that drive it. Also, I don't know if I was clear about this, but in my job role as a clinical ethicist, I do not practice law. So I left law to become a clinical ethicist, and one of the challenges that I didn't mention, and I kind of wanted to, was that David introduced us by talking about telling stories, and bioethics is about stories, but to me, law is also about stories, and as a lawyer, though, I crafted the story for an outcome, right? When I represented children, I wanted a certain outcome, or when I was doing appellate law, certainly, like I had that outcome, and the entire story I told in my brief, or when I was a trial attorney, the entire story I told standing up in court was to get a certain outcome. As a clinical ethicist, I have to be outcome neutral. It's all about the process. It's all about sometimes slowing down the process. It's about hearing the multiple voices and trying to tell the patient's story as best we can, not as best as we imagine it to be or what we want it to be, but where it comes from within them. And that, to me, is sort of something that I really wanted to share, because I even think, as we have a biologist in the room, biology is about telling stories through cells, right? We are all, I think, in our lives, in our careers, storytellers, and there is a great responsibility to how we tell that story. And in clinical ethics and bioethics in general, I think that that's something we have to always have a check on how are we telling this story and how authentic is the story that we're telling.
There is, in fact, an entire school of bioethics called narrative bioethics, which describes a discipline that seeks to create continuity in the story of a patient's life, even when they have lost their decision-making capacity. And that has its own intrinsic value. Yeah.
I had a quick question on the ethics review committee. So, like, what happens when you get a case where you mention, a patient lacks capacity and has no advanced directives, and you can't, there's no family that you can contact. What sort of, how does the ethics review, how do you guys make those decisions on what it is the patient wants, and what are some usual outcomes that you guys decide on?
So there are 4 principles of bioethics, 4 core principles. They are autonomy, beneficence, non-maleficence, justice, and humility. Right? I know that's 5. But somebody decided there were 4, and I decided that there were 4 under the umbrella of humility. And so what we do is we try to extend the values that the patient had before they lost their capacity by consulting with family members, friends, prior treating doctors, by reviewing the medical record and looking at what kinds of decisions the patient made and didn't make, and try to, and so we have a fancy term for this, we call it the best interest analysis. We try, in the first instance, to figure out what the decision would be that the patient would make if they could miraculously be able to express themselves. And if we can't do that, we look to other sources of information to justify both ethically and legally acting in the best interest of the patient.
But there are some specific statutory requirements under the Family Healthcare Decisions Act for doctors who want to make decisions for a patient who has lost decision-making capacity, and they differ depending upon what kinds of things might happen with the patient. For routine procedures, for example, I think an individual doctor can make those decisions. For a major operation, there has to be consultation with at least another doctor. I'm not sure if the ethics
For
committee has to be.
consent required, for a procedure that would require consent from whoever you're doing it for, then you would need just a second attending.
Right, and then for any decisions with regard to life-sustaining treatment, there has to be actually a court order, which gives the doctors the right to do this or do that, either in the life-sustaining treatment arena.
I think unless they
But
fall
there's a lot
into the
of wiggle room around
category
that.
of imminently dying with or without the treatment, and provision of the treatment would be against acceptable medical standards. But it is, the area you're talking about is a place where the law does sort of rein us in pretty tightly in making decisions for incapacitated patients without family members. So you can't sort of like willy-nilly say, I don't know, I'd never want to live like this person, so we're going to just, do a palliative extubation of this individual. There's a very thoughtful process that goes into it, and actually for me it has been the most touching and profound experience I've had so far working in clinical ethics, is sitting in a room with the medical director of the hospital, clinicians, PAs, nurse practitioners, nursing home representatives, hospice representatives, bioethics, and just sitting and thinking, what do we know about this person? How do we understand their values? And when we don't know something, how do we act in their best interests, as David mentioned? And really trying to be very deliberate about those decisions. And often when we don't know something, erring on the side of something that's least irreversible, which would be to continue the treatment or the life-sustaining treatment, and that sometimes comes up.
Balanced against the doctrine of medical futility, right? So all of the obligation and all of the presumption in favor of life has to be balanced against not doing things that aren't going to work, right? So keeping a patient who you know is brain dead hooked up to a ventilator in an ICU, that is inherently medically futile care, because there's nothing you can do to provide care for a dead person.
Right, and that's not the situation that we would ever get together and talk about. It would be
Those are easier.
much more nuanced.
Yep.
With the completion of the human genome and DNA research, how does this affect decision?
Where to begin? That's an entire course because it speaks to both the over-inclusive and under-inclusive nature of the information that genomics provides us, right? So, for example, when I was doing my bioethics training 22 years ago, the BRCA1 gene had just been identified. No one had any idea what it meant in terms of prognosis if you had the gene versus if you didn't have the gene. And so an ethical question that we wrestled with is, should anyone be getting tested for this? Because what use is the information? Now, 20 years later, we have that body of experience. We can look at people who were tested 20 years ago, and we can look at what their course was. We can look at the statistical probabilities that BRCA1 diagnosis or determination is indicative of a percentage of likelihood of disease, and we can help patients make decisions about all sorts of things, such as prophylactic mastectomy, prophylactic prostatectomy, all sorts of things that we didn't know how to advise patients about when the technology was first developed. Today there's technology that's being developed that we have no idea what the significance of the data is, but 20 years from now, or maybe only 10 years from now, we will have a better idea. But in genomics, more than any other area of medicine, the principle of medical humility is most important, because it is so easy and so dangerous to presume or infer that correlation is the same as causation. And it isn't.
Can I clarify something on the last question really quickly? Because I feel like there was a conflation of different things. So we have an ethics consultation model at our hospital, which is an independent consultant model. Which means that when I take the call, I work on that consult and I work it to the end of the process. And if I need assistance, I'll call someone in. And it's often, that's sort of more casual, but that happens. But in Ethics Review Committee, it's very specific, set up statutorily in the Family Health Care Decision Act, and it has to include at least 2 people who are clinicians, one of whom is a nurse, a community member, and this is, actually, I don't know if it needs to be a social worker.
I think that can be the non-clinician.
And a community, did I say community member? A community member, to sort of make sure that there's this balanced, and at least 5 people, a balanced approach. So that committee, in my experience so far, has only been called to talk about placing a patient alone that I've talked about in hospice care.
But that's the consultation model. There's another model of bioethics consultation where the committee is the consulting body, and families actually come and sit down with either the full committee or a cohort of the committee. And then the third model is where the committee exists to be the advisory body to the clinician, but the clinician remains the point of contact with the patient or the family. And there are obviously advantages and disadvantages to each of the 3 models. There are hybrid versions, and no one model is right for every hospital, because obviously a large hospital like Montefiore with a very, very long history of bedside clinical consultation is going to have a different set of resources than a small community hospital in the Adirondacks, or someplace, with different socioeconomic resources. More questions?
So I'll piggyback on the first question about getting a JD, because it seems to me, I'm looking into going into law. I'm just still exploring my options. I got my master's here in Columbia, but it seems to me in order for you to be a credible bioethicist, you need some sort of terminal degree. So I know that you go into clinical ethics, everybody is doing a JD, MS combined with a Master of Bioethics in order to get that well-rounded experience and knowledge, and however you want to call it. So even though you're saying that a JD is actually not necessarily as helpful coming into bioethics, that's kind of what I thought.
Not necessary.
Not necessary.
Not to be confused with necessarily helpful. It can be enormously helpful because the number of paths into bioethics right now are still relatively few. Finding one of the routes that the 4 of us has taken through law into bioethics is probably the surer bet.
But if you're looking at it long-term, being a bioethicist, you definitely do need a terminal degree.
Yeah,
You can't just have an MS and think that you, because everybody that looks at in clinical ethics committees like yourself, or in IRBs, or doing clinical contracts in clinical trials, has a JD or a PhD or an MD, and that's how they're able to get that credibility.
Right. The Masters in Bioethics is starting to substitute for the JD and the MD. There was a whole group of us who came up in this field when there were no terminal degrees. The first certificate programs literally, mine was the pilot program here at Columbia, and that was 22 years ago. So that's changing. I think it's changing for the better. There will always be lawyers and doctors who find their way into bioethics without a master's degree, but there will be increasing numbers of opportunities where the master's in bioethics is the preferred degree in the job description.
I was just gonna, add that it also depends on the work you want to do in bioethics, really, because a lot of bioethics consultation services in hospitals, so doing what I do, are made up of people who are otherwise employed in the hospitals. So it could be an RN in the hospital, it could be a social worker in the hospital, who then do some sort of certificate and training program in ethics consultation and perform ethics consultation, or...
Could be a lawyer in the hospital.
Yeah.
Right.
I don't know.
Hmm?
I mean, I think it potentially could. I feel
In
like
smaller
there could be
hospitals,
some
it's
conflict
fairly-
there, but I don't know how all hospitals operate, but I think that, so if that's what you wanted to do, there are avenues, but you would also have to be pursuing some kind of work in a hospital setting otherwise. But I think you're correct in that a lot of the fellowships in clinical ethics require terminal degrees, but I have seen what David's saying, or masters in bioethics, but you know, that I think is evolving.
We've run over a little. I'm grateful to all of you for staying. I will stick around if there are more questions.